My name is Alex Tsarkov. I am the Executive Director of the Connecticut Sentencing Commission, and I'm very pleased to be moderating this panel on lessons learned and the path forward. I have to say it's quite refreshing to be able to have a rational conversation about this topic of sex offender management and registry. Sexual abuse crimes are very serious and often cause irreparable harm. And it's precisely for that reason that it's important that policymakers, legislators, and other stakeholders think very carefully about the measures we take to prevent that violence. And these are difficult topics to talk about, but it's absolutely critical that we do so. So we're going to continue doing that with this panel. With me today, we have Laura Cordes, Executive Director of the Connecticut Alliance to End Sexual Violence, Judge Robert Devlin, Chair of the Sentencing Commission, and we have two legislators, Senator Kissel, longtime ranking member of the Judiciary Committee, and for the last two sessions, co-chair of the Judiciary Committee, and Representative Steve Stafstrom, who serves as the Vice Chair of the Judiciary Committee. I'm going to get us started with a few questions, but I hope to very soon turn into the audience for your questions. Let's begin with Judge Devlin. You mentioned in your opening remarks the study conducted by the Sentencing Commission on the issues of sex offender registry and management and sentencing. Could you talk about some of the findings from that study and talk about the recommendations that we will be sending to the Judiciary Committee?
Sure. So we did not start off with any great expertise in this area. We've heard today from people who have spent their lives studying these topics, but we're not like that. We're practitioners, judges, prosecutors, public defenders, members of the law enforcement community. As I said before, the Sentencing Commission is composed of sort of all the stakeholders, but we're not experts in sex offender analysis or treatment or things like that. So we started off with considering, a fundamental question, which was, do sex offenders, pose a spectrum of risk? Is there, are some sex offenders more risky to reoffend than others? And so if you look at that question, there was pretty much unanimity that that's true. And we can see that in our day-to-day work, in the sense that the cases that we deal with, I'll speak for myself, the cases that I deal with in court, there's a wide variety of offenders, of offenses, all under this sort of general banner of a sex offender. But they're quite different people, they do quite different conduct, and they pose quite different risks to public safety. And so that was manifested in what these experts told us about, yeah, there's a real wide range of risk that's involved in these sex offenders. But our registry doesn't make that determination. So right now, in Connecticut, we have approximately 5,600 people on the public sex offender registry. We have about 80 people on the law enforcement only registry. So there's this tremendous sort of difference between those two populations. So with that 5,600 people, if there's a wide spectrum of risk within that group, which I believe there is that registry really doing what we want it to do? In Minnesota, they have a risk-based registry, and they've got about 15% of their sex offenders on the public registry, and the 85% are on a law enforcement-only registry. Now, I'm not sure those numbers would match up in Connecticut, but they probably would match up pretty closely, which would mean that of our 5,600 people on the sex offender registry now, maybe like 800 or 900 are people who really pose high risk. And maybe those 800 or 900 are the people that really our citizens should be worried about if they're wondering whether their kids should go out trick-or-treating in a certain neighborhood or something. And so we looked at that, and we first came to the view that we should really explore the possibility of converting from a strictly offense-based registry to a risk-based registry. And once we got to that point, then it was doing the hard work of, well, what should this thing look like? Who should assess the risk? And what should be the implications of that? And again, we're pretty quick to realize, since we're not qualified to do this, we need to have people making these risk assessments who are qualified to do it. And in our professional population in Connecticut, we realized that we could probably tap into people who are involved in victim advocacy for victims of sex offense, like Laura Cordes and her group. People who worked in assessment of sexual offenders, like David Rentler, what he does for the Board of Pardons and Parole and others, and people in court support services who have a lot of experience in the management of sex offenders. And so the idea was to create a credentialed board of people who had really deep experience in this area to make these assessments. Is this person high risk, moderate risk, or low risk? And which hopefully would be sort of a reliable way to make this determination. And then the question is, what happens after that? And so this board would make a determination, well, these high-risk people, they should be on a public registry. Those are the people that we want our citizens to be able to identify. Low-risk people should be on a police registry. So if police officers are doing an investigation, they can properly assess that. They can know where these people are living. They could have their current photograph. They could have the information they need to pursue their investigations in a reasonable and hopefully efficient and successful way. And then in the middle, these people who scored moderately, well, we rely on the professionals in these boards, and we'd have like 8 or 9 people on the board, and they sit in panels of 3, and they make these assessments to determine if someone fell into that middle category. Well, looking at the offense and looking at sort of the whole complete picture, should they be in the public registry or just the law enforcement registry, and rely on their expertise with respect to that. So essentially, that's the basic conclusion that we came up with. And then we sort of looked at, well, how should this thing be further sort of structured? We felt that it shouldn't be a completely static situation. That is, someone, after a number of years, could move from, say, the public registry to the law enforcement registry if they had a meritorious case to do that. And conversely, if someone who was originally sort of put into the low-risk category and only the police registry, if by their conduct, they manifested the fact that this person's way more dangerous than we thought they were, they could be moved up to a public registry. So built into the system was some flexibility for that. And then we determined there should be a path off for certain candidates who really posed, maybe through passage of time, law-abiding activity, compliance with the registry, a combination of factors where someone could make a petition to a judge, and a judge would make a determination if that person was someone who should be removed completely from the registry or not. And we also had to confront, in our work, the question of, what about people who were placed on the registry? One of the issues that came up was retroactivity. If we proposed something that the legislature thought made sense, and they were willing to consider it and maybe willing to vote for it, should it be only prospective, or should it have some retroactive effect? We heard a lot in our public hearings on this, that victims groups were very concerned about the retroactivity effect of a change in the registry. Because as these cases work their way through the court system, and I know this is in fact absolutely true, victims are very concerned about other people being victimized by the offender that hurt them. And so they saw the sex offender registry as a way in which they could maybe affect that and to protect other people from being victimized. And so there were very strong feelings about that, and so we came to the conclusion that the registry should be prospective with one exception, and that concerned people when they committed their offenses, there was no sex offender registry. For a long time, the sex offender registry came into effect, around 1990, I think. I don't know the exact date in my mind, but there are people who were committed sex offenses before that date, and in different iterations of the registration, it was made retroactive, and so even though at the time they were convicted, there was no registry, they were pulled into the registry because of subsequent changes in the law. That was challenged in court, and that was deemed to be an appropriate action, making it retroactive. But the commission felt that people who were not subject to the registry when they committed their crimes and were convicted, they should have an opportunity to petition for removal of the registry if it was deemed to be a meritorious case to put forward. And so we've created this proposal, which sort of incorporates those ideas, which would move Connecticut from your offense of conviction would be a portal onto the registry. But then where you stood on it, both initially and going forward, would really depend on the level of risk you presented to our citizens. And so that's, in a nutshell, what we took from our two-year study, and which became sort of both our Special Committee on Sex Offenders and the Sentencing Commission as a whole endorsed in a generally consensus basis for our proposal to make to the General Assembly.
Thank you. Laura, you co-chaired one of the subcommittees of the study. Could you talk about that work and what came out as some of the recommendations?
Sure. Good afternoon. For those who don't know the Alliance, I do want to take a second both to thank the Sentencing Commission for bringing us together today, but also to note that the Alliance is a coalition of the 9 community-based sexual assault crisis service programs. Our mission is really twofold, to end sexual violence, create communities free of sexual violence, and then to center the needs and voices of survivors. And I think through the conversation today, I was so glad that Dr. Wilson, you were here to talk about some of the good work and really, I think, validate for many of us who've been at this for years that we are doing some good work in Connecticut, especially when it comes to collaboration and risk assessment. I think our lens over the last 3 years and working on the Sentencing Commission Special Committee on Sex Offenders and the work that we did, and I know Sergeant Garcia is here from the State Police and the Sex Offender Registry. We co-chaired the subcommittee on community and victims' needs. And in addition, I think a lot of folks think the work was solely around the registry, and I yesterday was at a Sentencing Commission public hearing, and I reminded commission members, that it's our expectation as victim advocates that the Sentencing Commission work to uphold all of the recommendations that were put forward in the report. So while the state is considering changes on the registry, we also talked a lot about what's still needed within the criminal justice system. So as we're changing it and reforming it, how do we bring the voices and needs of victims along and keep thinking about community safety? And some of the recommendations, I will say, our concerns and our support for the reforms on the registry are really contingent around 3 things. One, that Judge Devlin already mentioned, that it be prospective. We can't go back on sentences and promises that were made to survivors of these crimes. We simply can't change what was promised to them. And secondly, that victims and survivors be involved and understand what might happen when someone would petition the board that we imagine. And that they would not only have that information, but be given an opportunity to present information or their concerns about the person who harmed them moving from a public to a private registry or moving off a registry. And then lastly, Judge Devlin also mentioned that the board actually be very specialized. We have over 20 years of expertise, and this doesn't get talked about a lot, but Connecticut does something that no other state in the country does. And when we talk about collaboration for supervising, managing, treating sex offenders in the state, we have a best practice collaborative model that brings together victim advocates. I have folks from my team, post-conviction specialized victim advocates that are centering the needs of survivors. We have great folks from probation, parole, state police that all work together, and treatment providers that are thinking and holding space both for victims as well as doing the risk assessment, thinking about the conditions of offenders and helping them re-enter the community and live good lives and lower recidivism. And that is why earlier today it was mentioned that we have some lower recidivism rates than the rest of the country. And I do believe that's because we've paid attention to the collaboration here in our state. But the multidisciplinary board would then reflect some of that expertise that we've had in our state. And important to us as victim advocates and representing the needs of survivors is that we have 2 folks on that board who have specialized in actually doing the advocacy and victim service support for sexual assault victims specifically. And lastly, I would say in terms of one of our concerns about the registry and our support moving forward is that it would have, if the legislature does move to change the registry, that a multidisciplinary team, a planning team, be created at the same time. A lot of what changes we see in the criminal justice system in Connecticut, and certainly elsewhere, is that very good intentions, so an agency is charged in making a change, and lawmakers can direct that, but then there's a smaller set of people that make that change, and when that change happens, there are a lot of folks that weren't involved, and victims, and sometimes even offenders don't understand what has happened, and we're left scrambling to make the system work. When we're involved earlier on, as we're proposing with this multidisciplinary group, we can make sure that there's information, and certainly for victims to know when there's a sentence that involves someone on a registry, what their rights and information they'll be provided should that offender petition to come off the registry or move from a registry. I would also bring to the attention for folks who may want to go to the Sentencing Commission website and look at the report that was produced that came out last year at this time, the full set of recommendations. And when we think about changing the criminal justice system and elevating the needs of victims and survivors, and even focusing on prevention, the conversations that were happening earlier today about really going upstream. The Alliance has been doing that work for years, going upstream. We need more folks to come along with us, and hopefully today I'll be able to talk about a few things that you can do in your communities. But there's a provision in statute right now, and I think it's maybe 10, 12 years old, where we said that within available funds, we'll create a program and go in the community and educate folks about what we know about the real risk of offenders, about prevention education, and and talking about our model in Connecticut and really where the supervision and treatment and management is happening in the state. And that program was funded for about 6 months, and it hasn't been funded since. So when we talk about changing our culture and talk about really erasing and eradicating the myths, both of who's a victim, who's an offender, and how we can change the attitudes and behaviors that lead to first-time perpetration, we need more prevention dollars. And one of our recommendations is to make sure that we fully fund and support some of the prevention initiatives that are already in statute.
Thank you. Let's turn to our legislators. We heard some very good arguments today in favor of changing the nature of the registry, and there's really no evidence that the current registration regimes do anything to prevent sexual violence. But the politics of this is very tricky, to say the least. Could you talk about how you approach these issues?
Sure, I'll start. First of all, I want to thank you, Alex, and the Sentencing Commission for allowing me to participate this afternoon. I did see some of the earlier speakers from the overflow courtroom, and it was quite illuminating. Just to be clear, I'm State Senator John A. Kissel, serving the fabulous people of Enfield, Somers, Suffield, Windsor, Windsor Locks, East Granby, and Granby, North Central Connecticut. And I just want to say that when I was looking for the building, I think he was like a student on work study because he was raking leaves, and when I asked him for directions, he had to take out his earplugs. He goes, "It's that building that looks like Hogwarts." And I got to be honest, sitting up here looking at you guys with those windows, it is like Hogwarts in here. So the politics, well, the politics is not viewed in a vacuum in the Legislative Office Building or when we get in session over at the Capitol Building. We've got a lot of moving pieces. Certainly I understand the recommendations of the Sentencing Commission, and I think that what we have is a rather static instrument that has some use to the public, but not a huge amount of use. I'm not saying that I live in the worst section of Enfield, but I live like on the outskirts between the historical section and Thompsonville, for those of you who know. One time I went on there and it's like, 16 dots pop up, and I don't know. I'd have to go and examine. And the other thing you don't know is what were they originally charged with? And these are like, if what's on the record that you can discern maybe pled down substantially. So, 2 dots that might even have the same conviction, same crime, could be 2 totally different individuals. So limited ability to help the public. That being said, we'd be living in a vacuum if we didn't recognize that at the same time, we're in the midst of an extremely powerful #MeToo movement, where many of my colleagues, not just women, but folks, different parties, doesn't matter, but they want to see changes in how we prosecute and the potential sentences for predators and people that commit sexual crimes. They want to change statutes of limitations. They point to the Cosby conviction. And so then you get to the point where if you're going to cobble together support for something like the recommendations of the Sentencing Commission, I'm going to bump into legislators, either folks on the Republican side, of which I am, or folks on the Democratic side, and they may simply feel that if we're pushing for tougher sentences and changing the statute of limitations, that adjusting the system of registration, even in a rational manner, may dilute the political message they want to send, and therefore it undermines the ability to sort of cobble together a collection of individuals that can support this legislation in both the Senate and the House. So I think one of the best things that we can do going forward is, of course, these proposals, in my opinion, will be raised for discussion, and we'll have full public hearings as we always do here in the state of Connecticut. But I also will be looking to folks like Laura and other advocacy groups, because the best way for legislation, even the best ideas, to fail is you don't bring all the stakeholders together at the outset. Everybody has to have some interest in the outcome, and they have to know that their views are being heard. And so I appreciate the hard work that the Sentencing Commission does in analyzing these issues and looking at them from all different directions. It's invaluable to us in so many ways because they're able to do it when we're a part-time legislature and we're pulled in various directions. I mean, I've been lucky enough to be on the Judiciary Committee for 24 years, ranking for about 14, 16 of those years, and was so lucky to be one of the co-chairs over the last 2 years. It's a great committee. Sometimes there are issues that divide us along partisan lines, but more often than not, you're going to see folks come together across party lines. Representative Stafstrom, who I'm hoping, knock on wood, will ascend to a leadership position on the committee, has been great to work with over the past several years. And we, who are either ranking members or vice chairs or chairs, we all come together and we want to work. And even if we're going to disagree, and I was just talking to Steve earlier, even on a bill that I know ultimately I'm probably going to vote no on, I'm going to want to try to make it the best bill it can be, even though ultimately, decriminalization marijuana, I ended up voting no on that, no matter how you feel about that issue, but I made sure that there were provisions in the law that, in my view, help protect minors and other individuals that might be more susceptible to temptations at an age where they might be more impressionable, things like that. So it'll be very interesting. There's a lot of moving parts, a lot of new individuals in both the Senate and the House. My Democratic colleagues have much larger majorities now than they had going in, and I've been around long enough to see these things, these cycles, and we're all going to have to work for our constituencies and for the betterment of the people of the state of Connecticut. But I also recognize that if there's someone that's been sitting on the registry for years and years and years, I've heard the stories where, they're subsidized housing or under certain regulations within the city. Now they're going to be kicked out and, they're can barely get along, ambulate, let alone be a predator. And yet the laws are such that trying to get someone off the registry is like almost impossible. So we need a more nuanced registry system, in my opinion. It's not impossible. We have systems set up throughout various levels of government to address risk. When the horrible crime that took place in Cheshire with Dr. Pettit and his family, we put the brakes on and essentially came to the conclusion that we needed to shore up how we do things in Connecticut at every step of the criminal justice system, whether it's law officers stopping someone on the street or in their car, all the way through to someone getting out of the Department of Corrections. And we have people with this expertise already. And it's called the Board of Pardons and Paroles, and they look at individuals that are convicted of horrific crimes, and they make determinations about risk, danger to society, and at the same time, the reaction that they will receive if they make a bad decision and someone goes out and reoffends. So I think we have a pool of very talented men and women in our state that we can tap into, great advocacy groups, and the Sentencing Commission, and I look forward to working with my colleagues on both sides of the aisle. Should I be lucky enough to land on the Judiciary Committee again as ranking member. And I'm looking forward to your questions, and again, Alex, very honored to be here this afternoon. Thank you.
So, thanks, Alex. Thanks, John, for that lead. And I agree. A couple things I want to add to what Senator Kissel said. I think, first, obviously, a bill like this has such a better shot of actually becoming law and going far in the legislative process when the work is done ahead of time. I mean, the fact that this proposal came out a year ago now, it's been out there. Interest groups have had a chance to weigh in on it, to provide some feedback. Certainly having a conversation like we're having today of where could the potential pitfalls be, as we sometimes say in the legislature, how does a bill like this catch flies, so to speak. Being out there and being transparent on the bill and what's in the bill, and what the ultimate framework of this is going to look like for the better part of a year now, gives a bill like this a better opportunity to pass. I think one of the other things that gives this bill a better shot is this is not the first time over the last couple of years that the legislature has dealt with an issue of moving to a risk-based system. As Senator Kissel said, we certainly have pardons and paroles, and they've been doing it for some time. We've moved to a bail bond system now that is a little more risk-based, and that obviously has been a topic of conversation of the benefits to moving to a risk-based system as opposed to an offense-based system. So it's not a novel concept. Certainly to those of us in leadership on the Judiciary Committee, to the membership of our committees, but to legislators at large. But let's not kid ourselves, right? I mean, we're still. It's not most legislators. Most folks don't go up to Hartford saying, "Gee, I really can't wait to talk about paraphilic disorders all day long, and how we measure categories of risk 1 versus 5, and some old guy who's dying, I don't know, I missed half of it, but of sort of how you bucket that in and why that makes sense. What legislators generally react to is they react to either a large-based public outcry on something. Take the post-Newtown gun bills, take pushes to change budgetary constraints, be it whatever it is, whatever's dominating the news cycle. And really a moving to a risk-based sex offender registry is not dominating any news cycle in the state of Connecticut right now. The other thing legislators react to is they react to direct outreach from their constituents. Unfortunately, I don't know that there are that many folks who are affected by the failures of the current sex offender registry that we have now that are willing to go to their legislators and say, here's my story. I live in your district, and here's my story. Here's how the current system has prevented me from getting a job, from securing housing, from rebuilding my life, and has made our community less safe because I'm not getting the services and I'm not getting the opportunity I need in order to get back on my feet. And so I think those are two of the main headwinds. I think the other thing that we're going to have to deal with as we go through the public hearing process on this bill is there is a cost, right? There is a cost to changing the system here. There's obviously a programming cost to public safety. There's the per diem for the 8-member board. There could be other costs associated with that. That's not necessarily the concern of the Judiciary Committee, but if a bill gets out of the Judiciary Committee, it certainly becomes the concern of the Appropriations Committee as a bill moves along the process, especially in years of tight budget cycles. So I think those are, well, it's a very good bill, and I think one that certainly deserves a robust public hearing and discussion this year. There are a couple headwinds that I think we should be truthful and honest with before we enter back into session the first week of January on it.
Thank you. Let's take some questions from the audience.
When he needs it to.
Hi, you just mentioned that sex offenders they don't petition the offices asking how the registry negatively affects them. There's a state statute saying that felons cannot really congregate. So how is that possible? If they do want to get together, if it's just one person, their voice may not be heard. If it's a collective group, they would probably be heard, but the state statute says they can't really congregate. So is that a flaw in the laws, or how does that work for them?
Could you just clarify what statutes you're
Statute,
talking
yeah,
about?
I'm not aware of statute.
What's that? It's one of the stipulations that they're not to congregate, they're not to kind of be together and do public activities together. So
I'm not familiar with the statute. I'm happy to.
I don't know which statute it is. I just know that that's what we're told at our agencies, that sex offenders along with other felons are not able to really congregate together. So
Okay. I mean, I'm certainly not aware of any I'm not aware of any prohibition against contacting a legislator by individual folks. I mean, we, check emails and phone calls and the like.
Yeah, someone from up here, thank you, sir, said it might be a condition of the sentence that the judge, he or she meted out, and that might be sort of common amongst these convictions. But I listened to the very heartfelt testimony by individuals prior to Dr. Wilson, where people were saying, this person's my friend, I've known him, and actually questioning incarceration, let alone registration, for many of these individuals that are charged. And that's sort of the whole, what's the philosophical basis for punishment when there's a crime, and that can apply to any number of crimes, not just sexual predation in its various iterations. That being said, I heard that individual, and that person spoke with compassion. I don't know if he's my constituent or not, doesn't really matter, but that's a story that I will always remember. So folks that are convicted may not be able to gather and form a formal group, but I'm sure there's folks out there that would be allowed to form a group. They're in this room right now, and help to gather up these stories and then bring them to our attention in the legislature. So I think there's a variety of mechanisms, not the least of which is just, I respond to texts, regular mail, phone calls to my office, and especially people should contact their senators and their representatives, because if they're responsive, they are going to at least listen to your side of the story. Thank you.
I believe it was Senator Kissel who said we have the Board of Pardons and Paroles. Was that? Did you say that? That's involved?
Yes, sir.
Yeah. I don't know if you're aware of this, but there is a provision that people who have remained offense-free, I believe it's for 6 months after their incarceration, can apply for a good conduct certificate. And I did that, and I was informed that sex offenders are not eligible for that privilege. Now, I don't know whether that's the Commission's personal feelings or the mandate from the legislature, But I couldn't get a job for a very, very long time. And I stayed on public assistance, which was the first time in my life I ever did that. And I think that's something that, in addition to the work that the commission has done, needs to be looked at.
Well, first of all, I thank you for bringing that to our attention. I remember years ago working with Senator Coleman. Again, that was not a slam dunk kind of proposal. It was controversial. And I don't know whether the exclusion of sex offenders was part of some sort of negotiation that took place. But it sort of strikes me as odd. As much as it's clearly high victimization, quite often lasts with someone who is a victim for their entire life. But you know, if I'm a murderer or negligent homicide or something else like that, and I can get that certificate, to me, that's a disconnect. And I also want to paddle back. There's no bad place in Enfield, so if you were watching this on CTN, I don't want to get calls from that. Thank you.
I was listening to something that Senator Kissel had said. He said that we need to make sure that we have persons from all facets of this industry or this issue presented or represented. And I was listening to all of the individuals that we have on the commission itself, as a matter of fact, and I don't see many people that would actually be representing the defendants, the defense counsels, et cetera, represented. And that stuck in my head because I was also heard the statement that there's no issue that's really this worthy of listening to or that anybody is pushing forward. And the thought that I had was funding is always a dominating and current issue. One of the things that I think would happen if we had everybody represented on the commission is that we would be able to take some of the current people on the registry off the registry, not just saying, well, it's only going to be proactive, but we would be able to actually take some people off and, for instance, use that same funding to help in the prevention effort, which is what we're supposed to be about doing. So funding is always there. We know we're going to need funding for prevention efforts. If we're looking to see where we can get it from, that's a prime area to get it from. If you know that you have 75% of the people that are currently on the registry not a danger to society, which is what our impetus should be, then why aren't we taking them off and using that money for better purposes?
I mean, the commission has substantial representation from the criminal defense bar on our sentencing commission. And we have the chief public defender, who's a member of the commission by statute. We have a representative from the Connecticut Criminal Defense Lawyers Association. So, I mean, there are, that interest is represented there, and there are strong voices that we have that they put forward. But, I mean, what we're trying to do is actually sort of rebalance this registry so the people on the public registry are truly the ones that we see as most dangerous to our citizens and others being in a different situation. And if that saves money, that's great. But it's more about public safety where we're coming from on our proposal.
I'm glad it's a
I would just say, let's ask for money for sexual violence prevention, because while that argument works, I've never seen it in my 20 years where somebody says, oh, we'll save money here, and then they actually are able to put it into the line item over here for prevention, or anything else for that matter. But it is worth noting that the Centers for Disease Control, so when Eric was talking about the public health model of prevention, that doesn't roll off the tongue. That's not what most people think about when they think about how we're going to end sexual violence. Even thinking about sexual violence as a public health issue, we have to educate people on that. So when we grew up and folks said, oh, we're going to do prevention, it was focused on my behavior as a potential victim. So going upstream, we've passed a law in Connecticut that says mandates K through 12 sexual awareness and prevention education, age-appropriate, in the classroom, outcomes developed by the Alliance, Department of Education, and DCF. You can go back to one of the 169 towns that you live in, because we do it separately by school district, and say, what are we doing to reach those goals? And the town will tell you, we need money. It's aspirational, we don't have the expertise, and even if we had 100 new sexual assault victim advocates to go do that, we wouldn't have enough to teach all the kids. So we don't have folks grow up and choose to sexually harm folks in our state. So thank you for raising that on the prevention side. We can all go and ask, and I know it's hard in the state where we have a deficit, but to prioritize sexual violence prevention dollars.
Hi, my name is Cindy Prizio. I'm an activist with One Standard of Justice, and I probably attended more state meetings with the special committee and the work groups than any of the committee members themselves, along with my partner here, Maria Laskowski. We're no longer just a few straggler mothers or families. We're an organized organization. And Senator Kissel, when you talk about all stakeholders being at the table, we're not at the table. Whether it be my organization or another family or other statewide advocacy organization sitting in for the people who are convicted of sexual offenses, there's no one at the table. And in fact, conversely, there are multiple victim advocates and, everyone else is there, but no one representing families and the people convicted. So it's not that's wrong. Nothing about us without us. The other thing I wanted to say is that with these registries, the only thing my neighbor cared about was if somebody came on her street who was on the registry and she needed to sell her house, that the value goes down 4 to 20% depending on the community you live in, all right? It's a very costly price to pay for, plus the registry that by all evidence does nothing to promote public safety. And so what we're learning is that if the registry began as a civil and regulatory policy, wasn't part of sentencing, then the victim's impact at these petitions to get off the registry or us giving retrospective reform, which is what we want very badly, because it's the right thing. Anything else is morally, ethically, and constitutionally incorrect. And so what happens is that we're conflating, oftentimes, the trauma of a victim with the risk of an individual. And if somebody is no risk to low risk, then get them off a public registry. And here's what happens when we don't. In Tennessee, there was a family, one of their families. I just want to finish this story, Eileen. I will. A vigilante, a person with a gun went out and shot somebody's home, and he was living there with his family, and the bullets ended up on the pillow. Do you know the risk we're putting people on? The neighbors, when addresses are input to registries that are incorrect? It happens all the time. We've got to get it together here, and I'll tell you the last story. If I'm a 21-year-old man and I had an inappropriate relationship with a younger girl, but I went on to marry her and I'm now a father of 4 children with that woman, I'm still on the registry. Those are the people we're leaving behind without giving retrospective reform. So I am begging you to relook at this. Those reforms were done a year ago. It's time to we can do better. Thank you.
Thanks. Hi, I'm Maria, and this is for Senator Kissel and Representative Stafstrom. Okay, as the ultimate purpose is community safety, and the CGA's responsibility is representing your constituents. But one important element is missing. Your constituents also have members or the constituents themselves are registrants. They also need your help. They need help with housing, with employment. And if they can't get it, what are they going to do? Their families are being harassed, by vigilance and by, let me see here. I have it written down. They don't get, no one wants to associate with them because they can't get employment or housing. The restrictions, they can't participate in family, family affairs, or community, they can't get, be with family or get community support. So they also need your help. We all want safer communities, but if they're not allowed to get the help that they need, we're all in trouble. They're in your districts. They're in all of our districts, and they can't be left behind. If they come to you and ask you for help, I don't think you want to turn your backs on them. You can't. You're responsible for them. As, we are responsible for ourselves, for our families. But you're our representatives there, and we should be allowed to get help from you when we need it.
Well,
thank you.
Thank you.
Can I just ask a question real quick? And it's, yes, please. And it's about statewide and municipal residency restrictions. It seems like every year there are bills at the legislature that create these so-called sex offender-free zones. I'm just wondering how you see those types of proposals.
Well, I'm looking forward to any public hearing on that, but personally, I'd like to see the details, but as a general response, I don't typically favor that, because if you sort of create all these sex offender-free zones, then you get a bunch of sex offenders living under a bridge because it's the only place that they can congregate. So, I think the devil's in the details there, and if you really sort of play it out, you create these concentration areas, and I don't think that enhances public safety, nor does it afford individuals who are otherwise out in the community and trying to get their lives back in order. But that's just my response.
I'm a no. I think we see it, let alone sex offender zones that would be permissible. I mean, right now we see it de facto. As somebody who represents an urban section of our state, we understand that by and large, a lot of the social services and a lot of housing for folks reentering is sort of targeted and necessarily sort of stacked in certain sections of our state as it is already, and certainly any law that would make that even more concentrated would be absolutely problematic.
I have a question about the changes that have been proposed, whether they would apply from the present into the future or altogether, meaning retrospectively. And concerns have been raised about whether that may be inequitable. And I'm wondering, and this is for the panel, and also since there are a lot of Connecticut lawyers and legal experts here, is there anything in statute or the Connecticut Constitution that prevents you from doing it? Or is it a political call by the Sentencing Commission that you don't want to do that?
So I'll confess that I haven't done the legal analysis on it of whether there is a constitutional issue with changing the registry going prospective, but it's certainly, hint, hint, will be something I'll ask about in the public hearing on this topic.
My gut tells me it's a political question. And, Laura said that she feels that that would be completely unfair to the victims. That argument was made when we had risk reduction credits because folks went when individuals were convicted of certain crimes and prosecutors told them they're going to serve X amount of years. And then all of a sudden when we changed things and we started using risk reduction credits or good time to shorten sentences within the correction department for good behavior, taking classes, things like that, the victim community cried out and said, hey, that person was supposed to do 20 years and now they're getting out in 15. That's unfair. It's like a false representation to me when I went to their sentencing. So you run into that, and I think essentially, I don't think we're prohibited by statute or the Constitution, but we're torn in two directions as to, well, for X, Y, and Z, retrospective might be more just. But for the overall victim community to make that sweeping change, they can make a good argument that it's unjust because they were sold a bill of goods and now they're not getting what they were promised. And they will come up and tell me, I feel like I'm being victimized twice. And so that's a difficult set of interests that we have to struggle with. And I defer
So the Sentencing Commission did not see this as a legal issue. We saw it as a policy issue. And so we were very sensitive. I mean, the Sentencing Commission has 22 members, okay, and representing the full spectrum of voices in our criminal justice community. And so there were strong voices that resisted a prospective application of the law, and we respected that. We kind of reached a compromise. So if someone was on the public registry after a significant period of time, they could apply to this board to go into the law enforcement registry. And so that's one sort of option that was built into the proposal that we have. But we never saw this as a legal issue. It was much more policy driven.
You know, we're working, and thank you, Senator Kissel, for making our argument so well. But, you know, here we are at a time where our culture is saying, oh, well, victims, especially victims of sexual assault, will come forward. Well, we know, certainly the Me Too, Why I Didn't Report stories paint a very stark picture of how it is that victims are minimized, blamed, shamed, threatened sometimes by the people who harm them or their family members or friends. So to get over all those barriers, to step forward, to report, for then an investigation to be held, to tell your story repeatedly, to enter the system that takes sometimes years to move forward on a case, to finally have a conviction, a sentence, and then to be told later, not only an injustice that we're going to take that back and change the registry requirements, not only a re-victimization, but for that individual, but think of the message that that sends to other survivors of sexual assault who are thinking about whether or not to report, and think about that message that it sends to the community at large about our criminal justice system.
And I just want to be clear. I mean, there's two conversations here. There's the issue of should we have a prospective versus retrospective bill, which I think is what Laura's talking about. I think the other concern, and the one I have, is it permissible to do that as a matter of constitutional law? I mean, we saw this with the death penalty repeal in Connecticut, right? The legislature passed a statute that said you can repeal it prospectively, but not, and leave those retroactive convictions in there. The Supreme Court ruled you can't do that. So I think that to me is the bigger question, is not should we do it just prospectively, but first, can we even do that, or is it a all or nothing conversation, and if so, then it needs to be presented to the legislature in that manner.
And I would just add, under the proposal, certain registrants can never get off the registry completely, but they can petition to go to the law enforcement only registry. So that is built into the proposal. And look, this was a massive effort. We had over 50 individuals and different groups involved, and many compromises had to be made. That's just the reality. As Justice Borden used to tell us often, let's not make the perfect be the enemy of the good. And the good here is way better than what we have today.
How much more time do we have?
I think let's take one last question.
Okay, I'd just like to make a comment. The criminal justice system needs major, major reform, particularly in Connecticut. And there's more than one way to address problem behavior, including problem sexual behavior. And I think that the prison system has always had good time, dating back to the 80s. And it used to be much more liberal than it is now. I think that there's a lot of ways to resolve the issue around problem sexual behavior and future prevention, and that's treatment, treatment, treatment. And people change. I've seen men transform themselves over a decade or two, and that needs to be essential element to any assessment of early release or even being taken completely off the registry. No one's going to be happy with the Sentencing Commission determinations, I'm sure. I think we have to, as you said, Alex, accept something that is going to work in balance for everyone in our state. But again, I think the criminal justice system has to be seen as bigger and broader than just punishment, prison, and then post-supervision. It has to be more than that. So I guess I gave myself the last comment. And I'm happy to hear a response from anybody here. And just a comment, I worked for survivors for many years, and a lot of them said, I want this guy never to do this again. I want him to get treatment. I want him to be better. And for family members who were victimized, they love the person that harmed them. And I've spoken very recently with multiple people who are reaching out to their perpetrator to reunify so that their families can be together again. I think that's pretty powerful stuff.
Right. Judge Devlin, do you have some final remarks for us?
Yeah, so, look, thank you very much for coming. I hope we sort of spurred some interest in this topic among you. And I want to give a round of applause to our presenters who are still here to do such a tremendous job. Thanks. Have a safe trip home. Thank you very much.